Yes. No, I'll sum up in 15-20 minutes and there is. Lord, on the last occasion, I had mentioned that it is very clear that the present system of Section 34 has created more problems than it has solved. It was intended to bring in a simple system of arbitration and so on, but it has actually created more problems. There's a rigidity in 34 which has to be addressed. And that rigidity has been partly relieved by the legislature, partly relieved by the legislature, by inserting 34(2)(a), which is an admission. 34(1) by itself may not address problems which one may face, the courts may face while dealing with domestic awards. So Lordship will appreciate that 34(1) and 2, 34(2) deal with international awards and domestic awards, that is ICAs and domestic awards. But 34(2)(a) deals only with a domestic award. And there, Lord, they say that you can set aside the award to the extent of patent illegality, which was not the ground for 34(1). For 34 ground, you got the fundamental policy of India, shocking the moral conscience, etc. Now, my lord, the point I'm making is this. Today, my lord, we need not go into what is the meaning of patent illegality, what is the meaning of fundamental policy. That is not the remit in my humble submission of this bench. I am putting, Lordship,
please continue.
Yes. Lordship, 34. But the point I'm making, the Lordship sees 34.
34 is an additional ground. It's not really a ground which permits. 34(2)(a)
yes,
is an additional ground
for domestic arbitrations.
But it does not permit segregation or division of an award per se.
Per se, yes. Therefore, your Lordship is right. What your Lordship is referring to 34(2)(a)(4), which says that, yes, maybe that's what your Lordship is. But my humble submission is, the point we are making, and I think there cannot be an argument against that, that the power to set aside will necessarily include the power to partially set aside. That's a well-settled principle in our Constitution. The larger power includes the lesser power. You can't say either you set aside everything or don't set aside. To give a practical example, we'll have to see the law as to how it applies in practice. Now, all of us who have done arbitrations at some time, it is, in a sense, something like a civil case where there's a claimant instead of a plaintiff, we call it a claimant. Then there is a counter. Issues are framed. Invariably, my experience is the issues are framed by the arbitrators. If there's a counter claim, they'll take it together and issues are framed. Now, the point I made last time, at the time when the bench rose, was take a hypothetical case where the arbitral tribunal frames, let us say, 7 issues. Based on the pleadings, they frame 7 issues. And out of 7 issues, let us further assume that 2 issues, if I may use the word, are infected with patent illegality. They're infected with patent illegality. Now your Lordships have to decide. In such a case, do I set aside the whole award because it doesn't say partly, or the court can say these 2 issues are severable. They're severable. They're on a standalone basis. And I need not relegate the parties on all 7 issues back to the tribunal just because 2 issues are infected with patent illegality. But my humble submission is the word set aside can't be given such a rigid meaning as to make it inflexible and put it into a binary of a black or white. And once there is a patent illegality, the whole award goes. So my first request is, Lordship may see set aside must necessarily include partially set aside. That must be given, power must be given to the court. And I would submit it is inherent in the court. That inherent power is there. But I'll show Lordship a passage from Ashok Hurra and Rupa Hurra in a different context on curative, where Justice Kadri says, we can't, once we see a patent injustice, we can't be a silent spectator and fold our hands and say we can't do anything. You can do. Lord, on this partial setting aside, I don't think there can be much of a, in my humble submission, much of a problem, because if the court is faced with severability, then it can't be said that if it's 34-2, I will sever it, but if it is 34-2, I will not sever it. That will be an illogical answer. That if I'm a domestic award and I'm under 34-2, severability applies. But if I'm under 34-2A, certain sense of rigidity comes in, that cannot be the answer. The larger, bigger problem on a day-to-day basis is this, Lord.
There you are going on the assumption,
Yes,
that severability is possible.
Yes, that's my first limb. What I'm saying is, Lordship will imagine a chart, patent illegality, severable, non-severable. If it is severable, then to the extent of severability, partially set aside the award. That is the first submission. Now the larger problem now comes in. Suppose there is a patent illegality. Now first division is severable patent illegality, non-severable patent illegality. Now I'm coming to the second classification, sub-classification. There is patent illegality, and it is of 2 types. It's a curable patent illegality and a non-curable patent illegality. In my final submission, I'll draw the chart and give it to you. But I wanted to make the chart after getting your Lordship's reactions and hearing the other side also. And I'll show with examples how this court, where the illegality is curable, they have not set it aside and sent it back. They have cured it here and now. So what do I mean by curable and non-curable? What I'm submitting is, if the patent illegality goes to the root of the matter, just imagine Lordship is now hearing an appeal from the High Court. Lordship finds the judgment has to be set aside. There is nothing else can be done but to set it aside. The judgment is so unsustainable that the court sets it aside. At the same time, times innumerably, Lordship has partly allowed the appeal. Partly allowed the appeal. So my submission is, if the patent illegality is curable, why can't we say that the inherent power of the court includes the power to cure that illegality alone? Now, if a Lordship reads the section carefully, 34, I want to make a submission that only if is not confining the powers of the court, the only if is a maintainability. If you just read it with me for 1 second and I'll go to my last part. 34.1 and 34.2, Lordship will kindly see. 34.1 says, recourse to an arbitral award may be made only by an application for setting aside such award in accordance with subsection 2 or subsection 3. So that means that the setting aside can only be on the basis of an application. Can't be a suo motu. Now, an award may be set aside by the court only if the party making the application establishes on the record. It's been substituted for proof. So my humble submission is, actually an arbitral award may be set aside by the court on 2 grounds. that only if must be linked only to clause A. Also will appreciate it should be linked only to clause A, because unless the applicant brings it within 1, 2, 3, 4, 5, the application will not be maintainable. Now come to B. The court finds that. The court finds that. So typically what we do in real life, in day-to-day, is in our 34 application, if the award is suffering from an infirmity under 34(2)(b), we also add that as a ground that the award is contrary to policy of India, or it's not capable of settlement under the law for the time being in force. That's not an arbitrable dispute. That we add it as a part of an application. But that is not necessary for the maintainability. What I'm submitting is B indicates that there is an inherent power given to the court to address a case where the arbitral award is on a ground which is not capable of settlement. Suppose the party had not taken that ground at all. He satisfies 1, 2, 3, 4, 5. He doesn't take the ground that it is not capable of settlement. Like the Lordship have held, it's complete fraud, forgery, you can't go for arbitration. He takes that point. Or it's in conflict with public policy. That ground is not taken. Can a Lordship say that, no, I'm bound by the pleadings? No. Lordship will say, look, I see the award. I see it's non-arbitrable. I see it's contrary to public policy of India. Therefore, I can interfere and set it aside. There my submission is in 34(2)(b). Also, it is not all or nothing. If there are 4 disputes, 2 are not arbitrable, those 2 can be set aside. If the remaining 3 are arbitrable, let it go. Let it continue.
No, that's provided in clause 4 itself. So
No, but not in 2B.
Not in 2B.
Yes.
Now, the difficulty, there are 2 ways to interpret, though it's not strictly within our domain.
Yes.
Or the reference.
Ah.
But if one looks at subsection 1,
yes,
the recourse to the court against an arbitral award can be only made on an application for setting aside of the award in accordance with subsection 2.
yes,
Now, this will mean an application by a aggrieved party.
yes,
But if we look at B, the court finds that, so it, logically speaking, it says it will be only unless the party has taken recourse to an application in terms of subsection 1, the court finding will not be there.
correct. The court can't see when award is coming in the media, like I take under Article 2.
Or even if, say, executing court cannot.
Your Lordship is right. At the Order 21 stage also, he can't say, no, it's contrary to public policy, therefore I'm. Because by that time it becomes final and binding.
Correct.
Yes. No, what I'm arguing is, sorry.
The court hearing a 34 is not a creature of this statute. It is a court which independently
It's a
exists
2E court.
with its inherent powers.
Yes.
Under the old act also, 151 has been invoked wherever statutory provisions were, found to be deficient. Probably Ramji Dayawala in
Yes.
context of 34.
Yes.
Additionally, 154 to stay the suit. So we will also ask them, would 151 CPC
Yes.
be available to the court, because we can't treat the court as a tribunal, which is a creature of a statute.
Yes.
It is a court which exists with its inherent powers. Additionally, the power is conferred in this statute. Power is drawn from the statute in excess of its ordinary powers of a civil court.
Yes.
So what stops a court from exercising 151 powers where interest of justice warrants?
But can a Lordship also see
Didn't provide in the old act.
Yes.
Scenario which invoke 151 to stay.
Yes, and your Lordship is right, because definition of court is the court of the ordinary, the highest civil court in that district. So it could be the charter court, or it could be like in Bombay, Madras, Calcutta and Delhi, it is the high court. And in Bangalore, for example, we go to the district court. City civil court.
Principal judge of the citizen.
Principal judge citizen. That's in Bangalore, Andhra, we all go to city civil. Who won't go to high court?
Original site is only
Oh,
Bombay,
only Bombay.
only for Mr. Kambad. If read arises from, say, Mulund, it will go before a single judge. And if it arises from Thana, just across the road, it will go to the division bench.
No, from what your lordship is saying, if it's a Madurai bench, then again 34 won't lie. We'll have to go to civil court.
Because it lies only to
Quite possible. Principal court of that
Principal
place,
court.
yes. So, my lord, what in the light of what my lord Justice Vishwanath asked, recourse to a court, I mentioned yesterday on section 9 just before closing. Now,
So you can come to section 151 route. not
151 route also. Get the CP, 151 route also. Lordship will see 151. The same provision is also contained in Rule 6, Rule 9 of the Company Court Rules. In the Companies Act, they say so. They say that the court will have all the powers to do justice. You take Regulation 44 of the Income Tax Tribunal rules. Tribunal has all the powers to make in the interest of justice. Same thing in the CLB regulation. So what I'm saying is they confer it on a tribunal, but that need not be conferred on a court because the court has. Now the definition of court in 2 is 2(1)(e). Court means in the case of arbitration other than international commercial law, principal civil court of original jurisdiction in the district includes the High Court in exercise of ordinary civil jurisdiction, having jurisdiction. Now, my submission is following following Dulabai's case, old Hidayatullah judgment of Dulabai, unless the powers of the civil court are explicitly taken away, they will always continue.
implied that it will continue.
Pardon me?
It is implied that it will continue.
It will imply that it will continue. For example, the latest Companies Act, there is express provision that no civil court shall have jurisdiction to deal with matters of Companies Act. No civil court. Same thing, you take all the tax statute, no civil court shall. So the jurisdiction is ousted. So the law is basically jurisdiction is there. It has to be ousted. Here what they say is recourse to the court is there. So court has the power to grant relief. But that relief will be granted only on the basis of an application, as my lord the Chief Justice mentioned. Absent application, you can't act. But once the matter is in court, he expressly says the court finds that. And then they further amend.
Even if that ground is not raised.
Pardon me?
Even if that ground is not raised, but if the court finds that
Yes,
it
yes,
suffers from the clause 1 and
yes,
of B,
yes,
the court will be empowered to exercise the jurisdiction.
yes. No, it is not like the tax dispute. The question of law has not been raised, therefore I will not answer it. That is not the point. There also, my lord, they say in 260A, the power of the court is like the power of a civil court. Lordship knows 260A subsection 5. Even if you don't raise that question, the court can still deal with it. That is the so throughout the theme is that you maintain the powers of the civil court. So I'll just complete my submission by saying recourse to a court means recourse to a civil court. Keeping in mind section 9 read with section 151. The inherent powers of the court to do justice are always there, and therefore set aside must include partially set aside. Now I came to this issue. I'll come back to the issue of severability. Now in 34.
Just 1 minute.
My lord, therefore, my lord, my submission is that the recourse to the court under section in the 34, there is an implicit power of the court. To what extent it is taken away is limited by 34(1)(2) and 34(4). What are the limits to which the court cannot go? They are set out in the explanation. Kindly come to 34, explanation 1. Please come to explanation 2 of 34(2). For the avoidance of doubt, the test as to whether there is a contravention of the fundamental policy of India shall not entail a review on the merits of the dispute. So this is like a red line which says that, not at the heart of the day, they say don't make it a section 96. Don't convert it into an appeal. And my lord, perhaps the best discussion is that Lala Bansidhar's case from Delhi High Court, it came. What are the types of jurisdiction? There is an appellate jurisdiction, there is a revisional jurisdiction, and there is a reference jurisdiction in the old income tax cases where the High Court's jurisdiction is only on a question of law. The tribunal continues to be in session of the matter. The High Court decides the question of law, and then the assessment order is passed in the lines of the High Court order or the Supreme Court order. So your appellate jurisdiction, revisional jurisdiction, reference jurisdiction, and this is another kind of a jurisdiction called application jurisdiction, where it's a new type of jurisdiction. I'll give the Lala Bansidhar's case, very detailed discussion on what are the types of jurisdiction the High Court had. Get Lala Bansidhar. So there's an appellate, reference, revisional, and now it's an application where the power is limited. And what are the limits? One explanation is you can't do a review of the merits of the dispute. So as the Lordship put it, you can't get into the merits. You can't step into the shoes of the court. Lordship will note section 107 of the CPC says the power of the appellate court is as much as the power of the civil court. Under section 107 of the CPC, the appeal court can do everything which the law can do. Coextensive. This is not a 107 power because this is not an appellate court. So Parliament says, look, when you're discussing whether it's contravening fundamental policy, don't go to the review of the merits. Now, please see 2A proviso. Provided that an award shall not be set aside merely on the ground of an erroneous application of law or by a reappreciation of evidence. And it's erroneous application of the law, not a complete error of law itself. You apply the law erroneously. This is like the old Anisminic case. Once you have jurisdiction, you can err within the jurisdiction. Suppose you apply the law completely wrongly, then your lordship said it is perverse, irrational, and so on. So my submission is, section 34 has inherent power of the court. It is not taken away explicitly. The word is may be set aside. And the two explanations give a yardstick as to what can be done. Now, please come to 34(4) also, where also there's an indication. Now, 34(4) came bodily from the international commercial arbitration. Obviously, my lord, if the award is passed in ICC Paris or another country and it comes for enforcement to India, then what happens? In an international award, you're not an appellate court. You're not a court like 2E court. The definition of court in the UCITRAL is an Article 6 court, the court of that particular country. That court was not given the power to, they could set it aside and they could not enforce it. So what happened is, if it came before the court where the award was passed, they could be set aside. If it goes for enforcement, then the same grounds are there. For setting aside enforcement, same grounds are there. Now here what they did was, they said you can send it back to the tribunal. Now, I'm requesting your lordship to read 34(4). What does 34(4) say effectively? That instead of setting aside the award completely, because 34(4) will come only when an application is filed under 34(1). But if an application is filed to set aside the award, typically the other side will say, don't set it aside fully. Here is a ground to set aside, but that ground can be remedied by sending it back to the tribunal. Can we not say it's a curable defect? 34(4), because setting aside is the death of the award. That is the last remedy. So what the 34.4 contemplates, instead of going to the extreme step, now the ground for setting aside the award can be, when they had 4, when they inserted 2A, they kept 4 as it is. So the ground to set aside the award can be a patent illegality ground also. Appreciates that. They kept 4 as it is. Now the grounds to set aside the award are both in 34.2 and 34.2A. So the court will examine, the 34 court will see, look, this is the ground, yes, award can be set aside. Then you ask the next question, can I avoid the extreme step by sending it back to the tribunal? My humble request is, why not leave it to the discretion of the court to say, look, this is a matter where I need not send the parties back. If I can modify it, I can make change here itself, I can sustain the award. Why can't that power also be read into the inherent powers of the court? Why send it back? Because Lordship will see a practical difficulty. By the time the matter comes to the 34, 4 or 5 years have passed. And I spoke to my friends who deal extensively in arbitration. He's saying it's very, very often unworkable because the tribunal.
There's some difficulty in accepting this argument.
Very well.
Because if we accept that curable defects referred to by in your arguments, which the court can rectify, are relatable to subsection 4 to section 34, then it will lead to difficulty because 34.4 provides for a specific remedy.
Yeah. No, I'm not saying that you should
It
bypass.
can be argued by the other side that when a specific remedy and a method of providing for that remedy is, then we cannot
bypass it. Yeah.
bypass it.
No, what I'm submitting is, this is one indicia or one indication that if there is a ground to save it, because what I'm saying is 34.4 doesn't contemplate setting aside completely. 34.4 is a exit route or a window where you save the award by curing the ground on which it can be set aside. Now your lordships have interpreted 34.4 to mean it can't be a second bite at the cherry. You can't use 34.4 to make it like a review court and re-argue that case. So where the point is, now let's visualize what could be the ground to set aside the award. It could only be under 34.2 or 34.2A. Because patent illegality is a huge spectrum. It can be from a small thing to a large thing. We don't know.
But when subsection 4 describes a particular procedure.
I know that. I'm not saying that.
Nazir Ahmed principle. When a law requires to be.
Yes, Taylor versus Taylor thing done in a, yes, Lordship was right. Taylor, Singaram Singh, all the line of cases are there. You can't. I'm not saying that the court usurps the power of 4. I'm not saying that. The very purpose is given is, if this, now I'll tell you what, Lordship, what happens. Suppose the ground for set aside evidence is, suppose some documents have not been considered. In one issue, certain critical documents have not been considered. The other side says this issue has to be set aside because this critical document has not been considered. That has a material bearing. Now the 34 court can't go into appreciating evidence, summoning the document on. They'll say, all right, this document has not been considered. We'll send it back to the tribunal. Let them consider these documents and then decide the issue. That's what is 34 is contemplated. I'm on an illegality like a legal illegality, which doesn't require re-examination of evidence. I'm only saying, as my Lord Chief Justice is right, we can't say because 34.4 is there, the court can do the same thing which the tribunal can do. That is not my argument. That will be a wrong interpretation. I'm only saying there are various indications in 34 to say setting aside the award is the last resort. Wherever you can save it, try to save it. The only limitations are don't reappreciate it, don't do a review on merits. So my last submission, and I'll conclude with this, my submission is this. Partial set aside must be there. If the award is severable, my submission is, if the award is severable, because typically what will happen is multiple issues are there. It is not that all issues are patently illegal. Invariably, it will happen that 1 or 2 issues become bad. Like we all seen first appeals. When you go for a first appeal, the first court sees what are the issues framed, what are the answers on the issues, and then we argue that matter. All of us have argued first appeals and second appeals. That's what we do. But my submission is, apart from the classification of severable and non-severable, I'm now going into 2 points because curable and non-curable. Ultimately, we have to make sure that arbitration becomes a vibrant alternative force. Today, what's happening is with this kind of interpretation of saying that you can't touch it at all and all that, then people are going to be very hesitant to go to arbitration. And if I'm going to have an arbitration clause and after 7 years, I'm going to be sent back, no, now you set aside, start on your own, then what is the purpose? The whole purpose is completely lost. Then it doesn't become an alternative dispute mechanism. It becomes a dispute mechanism which will be forced upon me because I have no other power but to listen to the contracting party. So I have to get the contract, I have to sign that arbitration clause. Now, the second submission I'm making is, yes. Once you accept that there is a power to partially set aside the award, then my humble submission is leave it to the court because the limits are given here. Don't review on merits, don't reappreciate evidence, don't correct errors of law, application of law. Those limits are there. I'm saying, please examine this point, which I'll conclude with this. In my example of 7 issues, suppose the 2 issues are not severable. Infection affects the whole award. It's not severable. Then what does the court do? My humble submission is the court must then examine what is this patent illegality in these 2 issues which is infecting the whole award. If that illegality, patent illegality, doesn't require reappreciation of evidence, doesn't require correction of application of law, doesn't require a review on the merits, those 3 constraints, then the court can always say, look, instead of setting aside the whole award, I will remedy the illegality to the extent the illegality can be corrected, like a course correction. The award is off track, bring it on track and save it. And it has been done more than once. Lordship will kindly see those judgments. I'll give the example. Lordship will just note. Lordship will note citation. Indian Oil Corporation versus Ganesh Petroleum, 2022 4 SCC 463. 2022, volume 4, SCC 464, 463, sorry, 463. Here what happened was, the award altered the terms of the lease. They made it 20 years into 9 years or 10 years. They changed the rate of rent. Now you altered the whole thing completely. What did the court do? They said, no, if it's a 20-year lease, it should go back to 20 years and restore the rent. So what they did was, the award was modified to make it conform to the lease agreement, and it was then allowed to stand. That happened. Then take State of Chhattisgarh versus Sal Udyog, 2022 2 SCC 275. The award did not consider an applicable government circular. It was modified to bring it in terms of the circular. More examples I'll give. Sangyong, the Honorable Supreme Court says majority's award is wrong. I'm taking the minority award as the correct award, which I think is a very extreme example of modification. Suppose there's a dissenting award. The 34, can the court say that there are 2 awards in front of me? I will sustain the minority award. Or do you set it aside fully and send it back? Maybe one can take the view that if the majority is so patently wrong and the minority is a well-reasoned award, that's what been done by the Supreme Court. And lastly, Hakim. As far as Hakim is concerned, my humble request is.
Third one, you've not given us the citation.
Sorry,
Sangyong.
I'll give it in a minute. Sangyong and McDermott, I'll give both the citations. Sangyong is 2019, 15 SCC 131. And Hakim is of course in the referral order. 2021, 9 SCC, page 1.
2021,
2021, 9 SCC, page 1. This is part of the referral order. That's Hakim. That is National Highways versus Hakim. And McDermott, which is Justice Sinha's judgment, 2006, 11 SCC, 181. 2006, 11 SCC, 181.
I think I'm party to Hakim.
Pardon me?
I was part of the bench in Hakim.
Part of the in Hakim, yes. And I think Justice Sinha was the counsel in Hakim.
Council.
no, I was not there.
Yeah, she's counsel in? Sorry. Yes,
What is the page number of Sangyong?
131.
13.
Now, my lord, I have also referred to the case law compilation which we have given. Please see Vedanta. Vedanta, if the court master can put it up. Vedanta. Yeah, Vedanta 2019 11 SCC, page 463,
2019,
11 SCC 46.
It's 416 of a common compilation.
465, it is page 416 of the common compilation. You know, all the cases are in the common compilation. Now, please come to para 11 of this judgment. If they can put it up. Twenty 1911 SCC 465. PC para 11. That's important. May I read para 11? Read para 11. Yes. Yes. Please see para 11 in the screen. Lordship will see para 11 in the screen.
I've got the book.
Courts may reduce the interest rate awarded by the tribunal where such interest does not reflect the prevailing economic conditions. That's one part. Where it is not found reasonable or promotes the interests of justice.
Now, till this one, there are 2, 3 things. Can the court also increase the rate of interest?
Pardon me?
Can the court also increase? the
Yes,
rate
my
of
answer
interest?
is yes, because suppose the arbitral
That's
tribunal.
one. Just one. Now, if one goes by that, that means this is a complete case of merit review.
June?
This is a complete case of merit review
No, I'll tell you Lordship why.
because
Sorry.
it is rate of interest has an element of always has an element of discretion. Rate of interest always has an element of discretion until unless by statute that
Or by contract.
or contract is taken away.
Yes.
And as far as pendentalite is concerned, it's always under 34 also a matter of discretion of the court. Now, if one looks at the rate of interest provisions also, it says that where the arbitrator has not awarded interest, post-award rate of interest, then the statute itself prescribes the rate of interest. Can the court then read down the rate of interest? Suppose the award does not prescribe the rate of,
Can I give an example? Lordship?
but because then it provides that. So in this case, will you not read down that the discretion of the court is taken away? Because by default, if the arbitrator has not awarded post-award rate of interest, then there is specified rate of interest.
But on the interest issue, there is a problem here because the contract is 18%. Very often, if the other side is a public sector,
No,
then the court says,
The reason why I say the increase in rate of interest, because most of the government contracts, there's a specific stipulation, no interest will be awarded.
no, let's come to a contract where interest is awarded.
So the reason why I asked you
I
that
know.
was, and they're judges of this court, arbitrator is bound by those conditions.
Correct. In fact, in many of the government contracts, in many of the government contracts, other problem is, as a tax lawyer, they say that the price is all inclusive. Even if there's a hike in the taxes, you have to bear the cost. It also has been held to be valid. I'm not on that. I'll tell you a practical problem which we have faced in Madras. Many of these finance companies are there. Now they give loans for sale for car and motorcycle.
The rates of.
And now what they say, the interest is 18% per annum. Because they have to borrow at 12% unless they have the arbitrage, they can't sustain. There is a clause that if you default for more than 3 months, the interest becomes 24% or becomes 36%. Now, in the light of what your lordship said, in many of these things, there are arbitrations where they appoint lawyers to the small arbitrations. The default is 2,80,000 like that. Very often they seize the vehicle, only the balance they have to recover. Now, my submission is, if the contract says that a defaulter has to pay instead of 18, 24%, and if the arbitrator awards only 18, ignores the contractual rate, my humble submission is the court can change it in the interest of justice to 24. Why not? That's my question. And in fact, our High Court, or the Honorable Supreme Court has held, you can't have a separate yardstick for government companies. You can't have some kind of sympathy. If they have the clause, then they have to also have the thing. But to answer your lordship question, can you increase it? You can. Please come to section 28 of the Arbitration Act. That's very important, which we lose sight of. Section 74 of it. 28 is again borrowed from the UNCITRAL. They modified it in India. 28 is very important. Again, it is peculiar for domestic arbitration. May I read 28 1A, my lord? 28 1 small a. The lordship's got it, my lord? Yes. Where the place of arbitration is situated in India, in an arbitration other than international commercial arbitration, the arbitral tribunal shall decide the dispute submitted to arbitration in accordance with the substantive law for the time being in force in India. Now, this is a mandate given by the legislature. Once the arbitration is being held in India, if the place is in India, then the substantive law of India applies. Now, lordship gave the example of interest. What does the Contract Act say? The penal interest, the lordship takes section 74 of the Contract Act. They say that a clause, suppose I say it's 18%, but if defaulted is 48%. Suppose I make it highly issued. Then the Contract Act says such a law is in terrorem. It's in the nature of a penalty. It is not permissible. So the arbitrator can always say he has to decide in accordance with the substantive law of India. Section 23 of the Contract Act. If a clause is against the public policy, the agreement is void to that extent. So I am saying that the patent illegality can also be seen from 21A. If the arbitrator has ignored the substantive law of India, then the remedy is either to set aside the award or to make sure that it falls in line with the substantive law of India. Why set it aside? If you can just, like my Lord the Chief Justice gave the example of a formula. The arbitrator has not completely applied the formula, he has missed one particular part of the equation. You can just change it by saying that. One more thing as far as Hakim is concerned, my Lord Justice Vishwanathan asked the question, what about reversal? Set aside and reversal. My submission is, suppose the particular issue in the arbitral award has taken view X and the correct substantive law is view Y, then it need not be set aside. The arbitral tribunal, the section 34 court can simply say, look, I'm ignoring X, I'm going to put it as Y, which is exactly what your lordship did in Sal's thing. You said, you ignored the circular, I'm applying the circular, I'm doing it. To that extent, it is a reversal of what the arbitral award did.
Is that not varying? Is varying different from modification?
But we thought about it, we discussed it. But basically, we are on a fundamental basis. When lordship partially sets aside the award, are you not modifying the award? So are we not on a question of semantics? What UK, which learned solicitor has given, where there is the express power to modify the award, vary the award. Please see section 48 of the Singapore law, which it says, he has quoted. It says the court shall not modify the award under any circumstance, except as provided in the Act. That's 48 of the Singapore Act. 49 then says a domestic award can be varied, modified. The lordship sees learned solicitor's notes. You quoted section 48.
48 is
There is a bar.
in principle similar to section 5 of our Act.
No. 48 says,
47.
no, see, 47 says, lordship will kindly note section 47. In Singapore, the court does not have jurisdiction to confirm, vary, set aside, remit an award on arbitration and agreement, except where so provided under the Act. And provided under 49,
Of our Act.
And under 49, they say the court can, in that on appeal, the court can confirm the award, vary the award, remit the award in whole or in part, set aside the award whole or in part. Singapore 49(8), 49 subsection 8. Therefore, my lord, my humble submission is, ultimately, as I gave that note, I would request the court to add the words. I gave the chart on the last occasion, where repeatedly the court have added a few words here and there to sustain the award. And I also mentioned the court, Justice Vishwanathan noted it, on Seaford Court Estates with Lord Denning. Can I take that passage? No, I'll just give it in the course of my reply. Well, what Lord Denning says is, he says, acts of parliament are not made with divine prescience. English language is an imperfect instrument. So the act of legislature cannot cover every possible eventuality. Will the court master have the Queen's bench? Otherwise, Lordship will note the citation. Lordship will just bear with me. I'll just give it. A C4 Court Estates Limited versus Asher, 1949. To all ER, 1949, to all England reports, 155. Last time I gave it to the court master. 155. And Lordship will then come to the concurring judgment of Lord Denning at page 164. If the court master can put it, 1949, to all ER 155, I can show it. Otherwise, yeah.
All England reporter, not all India reporter.
All England report.
Or all ER.
All ER. Can I just read that passage, Manoj?
Yes,
Can I just read it and I'll conclude?
yes.
It's at page, starts at 155, Lord Denning's concurring views at page 164. Very nice passage. I'll read, Manoj. Whenever a statute comes up for consideration, it must be remembered that it is not within human powers to foresee the manifold set of facts which may arise, and even if it were, it is not possible to provide for them in terms free from all ambiguity. The English language is not an instrument of mathematical precision. Our literature would be much the poorer if it were. This is where the draftsmen of Acts of Parliament have been unfairly criticized. A judge, believing himself to be fettered by the supposed rule that he must see the language and nothing else, laments that the draftsmen have not provided for this or that, or have been guilty of some ambiguity. It will certainly save the judges trouble if Acts of Parliament were drafted with divine prescience and perfect clarity. In the absence of, now this is the problem, in the absence of it, when a defect appears, a judge simply cannot fold his hands and blame the draftsman. He must set to work on the constructive task of finding the intention of Parliament, and he must do this not only from the language of the statute, not only from the language, but also from a consideration of the social conditions which gave rise to it, the mischief it was supposed to remedy, and then supplement the written word so as to give force and life to the intention of the legislature. To put it in homely metaphor, a judge should ask himself the question, how, if the makers of the act had themselves come across this ruck in the texture of it, they would have straightened it out. He must then do as they would have done, that legislature would have done. A judge must not alter the material of which the act is woven, but he can and should iron out the creases. So my humble submission is, by adding 3 words as I suggested, lordships are not altering the fabric, you are ironing out the creases. I'm grateful.
By God's permission, may I follow Mr. Datta? But I am appearing in IA 9364 and 9401 of 25. I've also prepared an additional compilation of just the judgments that I wish to show my lots, which I will take my lots. Earlier I had filed a 3-volume, but I think this is much more handy. Just share it. The aim of arbitration, as my lords have held, in the interplay with Stamp Act judgment, is to provide speedy, efficient, and binding resolution of disputes. And there's a delightful passage from Redfern and Hunter, which my lords have also quoted there, which starts with the advantage of arbitration is expedition where the law is slow. The Act itself, apart from the objects and reasons, has a lot of internal evidence to show that speed and finality forms the fulcrum of the Act. Very briefly, Section 29A, the time limit of 12 and 6 months. 29B, fast track procedures. 34(6), disposal of 34 within 1 year. All these show that the intent of Parliament is speed and, of course, finality. Now, the question before your lordships is that if under 34, the court only has the power of annulment of an award, either wholly or partially, it would mean that a successful party who has succeeded, say, in 90% of the matter before the tribunal, has failed on one question of law, has then succeeded in the 34 in getting the finding of a court that this is a patent illegality, would then be relegated to restarting the entire process all over again from day one, which is an immeasurable cost, hardship, and completely contrary to the object and purpose of the Act. It would undermine the very idea of arbitration itself. Now, today your lordships are faced with this situation. Certain foreign jurisdictions, as the learned solicitor has shown, has got express provisions to vary. Our Act does not have an express provision to vary. And though the Dr. T.K. Vishwanathan committee has recommended that, that recommendation has still not been incorporated. So we are left with two major arguments against giving any power to modify to a 34 court. Let me state them straight away. One is that there is no express language in Section 34 itself. And coupled with Section 5, one is restricted only to the express language of 34. And the second is an alarmist one, that if a court allows modification, the floodgates will open and you will convert 34 into an appeal, which it is not. Let me address both of them. First, the source of the power. I intend to argue in two compartments. My first compartment will be that, in fact, 34 itself contains the power. My second compartment will be that in any event, the inherent power, particularly of high courts that are constitutional courts of record under Article 215, is never taken away, even when they sit under a special statute like the Arbitration Act. That will be a second compartment. I'll deal with that separately. And then I propose very briefly to suggest certain guardrails to meet the floodgates argument, because I don't think anyone who is pro-arbitration wants a complete, unfettered, unguided power of modification. And my submission there is going to be that that power can be hinged exactly within the discipline of 34. So, for example, patent illegality is a ground on which an award can be set aside. To come to that conclusion, a 34 court would necessarily have to determine what the correct position of law is to determine that there is a patent illegality. The only suggestion is in those cases, without reappreciating evidence, without allowing a reconsideration of merits, permit the incorporation of that correct position of law into the award with only consequential modifications. Therefore, that is completely within the discipline of 34, not outside. Now, may I go first to 34 itself? 34(1) is the source of the power. 34(1) tells us that recourse to a court against an arbitral award may be made only by an application for setting aside such award in accordance with subsection 2 and 3. So to have recourse to a court, you can have recourse only via an application for setting aside. You can't simpliciter file an application of modification or appeal. You have to first fit within the discipline of 34 to even have recourse to the court. But what you then have is recourse to the 34 court. Now it is very well settled that even when the express words do not indicate a wider power, if the wider power of annulment is conferred on the 34 court, that would include all lesser powers. And a lesser power would include the power to modify under certain restricted circumstances. This, as your lordships have held in the Sakiri Vasu case, is the doctrine of implied power. Would my lords just turn for one moment to the very first judgment in this compilation? That is Sakiri Vasu, 2008, 2 SCC, page 409. At para 18 onwards. In para 18,
Para 18.
para 15. Para 15 is section 156.3 provides a check on the police performing its duties under chapter 12 CRPC. In cases where the magistrate finds that the police has not done its duty of investigating the case at all, or has not done it satisfactorily, he can issue a direction to the police to do the investigation properly and can monitor the same. Power in the magistrate to award further investigation under section 156.3 is an independent power and does not affect the power of the investigating officer to further investigate the case, even after submission of his report under 173.8. Hence, the magistrate can order reopening of the investigation, even after police submits the final report. Then 17. In our opinion, 156.3 is wide enough to include all such powers in a magistrate which are necessary for ensuring a proper investigation. And it includes the power to order registration of an FIR and of ordering a proper investigation if the magistrate is satisfied that a proper investigation has not been done or is not being done by the police. 156.3, though briefly worded, in our opinion, is very wide, and it will include all such incidental powers as are necessary for ensuring a proper investigation. Then in para 18, it is well settled that when a power is given to an authority to do something, it includes such incidental or implied powers which would ensure the proper doing of that thing. In other words, when any power is expressly granted by the statute, there is impliedly included in the grant, even without special mention, every power and every control, the denial of which would render the grant itself ineffective. Thus, where an act confers jurisdiction, it impliedly also grants the power of doing all such acts or employ such means as are essentially necessary for its execution. I would respectfully submit that there would be an implied power in the 34 court to do everything necessary to save the award, even in cases where it finds that the whole award or part of it is vitiated by a patent illegality. And then para 20, in ascertaining a necessary implication, the court simply determines the legislative will and makes it effective. What is necessarily implied is as much part of the statute as if it was specifically written therein. So no need to write in any words. This doctrine allows your lordships to find that power in 34 itself, provided your lordships are satisfied that the idea of 34 is a recourse to a court, and the object and purpose of the act is to protect and further awards and to make the entire process speedy and final. In fact, your lordships may also invoke another doctrine, which is the doctrine of molding the relief. Your lordships will see the second judgment. Please turn to page 10 in ARCE Polymers 2022 2 SCC 221. And at paras 22 and 23, your lordships have enunciated the doctrine of molding of powers. 22 first, at running page 24 of the compilation. In consideration of the facts of the present case, another important aspect to be duly noted is the power of the court's judicial authorities to mold relief, while holding that the general approach is that the claimant who succeeds in establishing the unlawfulness of administrative action is entitled to grant of a remedial order. The general proposition does not undermine the discretion which the courts or judicial authorities have in assessing, quote, what is fair and just to do in the particular case, to withhold the remedy altogether or to mold the remedy by grant of a declaration rather than a more coercive quashing, prohibiting or mandatory order injunction which may have been sought. So your lordship,
This is in respect of something else.
something completely different, but the doctrine of molding the relief would equally apply to 34. Is the 34 court left powerless to actually remedy the situation and subserve the object of the Arbitration Act, rather than to adopt the harsher remedy of setting aside and then leave parties to their remedy, leave them anchorless for the next several years to restart and relitigate the entire matter in arbitration? I would submit no, a court always has this power. Merely because there is no express power given in the statute, that does not imply that there is a prohibition. I'll come to section 5 later, but first, the lack of an express power does not imply a prohibition. Your lordships in Centro Trade, the third judgment at page 27, and Hindustan Copper held exactly this. This is in 2017, 2 SCC 228 at para 23. Para 22 first, your lordships at page 42. I have referenced the previous judgment of this honorable court in ITI, where the question before this court was whether the provisions of the CPC were applicable to the Arbitration Act or not. In response, this court observed that since there was no express provision excluding the provisions of the code in the Arbitration Act, it cannot be held by inference that the provisions of the code were inapplicable. Now, I must tell my lords that in fact a subsequent bench of 2 judges, I put it in the compilation, has doubted the correctness of this judgment and has referred it to a larger bench, which is, and that reference is still pending. But today the thought that the CPC could also apply has already been held by our lordships in ITI and not departed from in Centro Trade. Then para 23. In any event, we are afraid the passage referred to by counsel from First Day Lawson has been misunderstood and is even otherwise inapposite, since we are not concerned with a statutory appeal, but a non-statutory process agreed upon by parties that has nothing to do with court procedures. We are also unable to fully subscribe to the broad observation that acts mentioned in a statute are permissible, but acts not mentioned therein are impermissible. So the mere non-reference or silence at highest of an express reference of the power to vary or modify does not mean that that power cannot be read into section 34, because there is no prohibition. And we see, for example, the example of Singapore. My learned friend, the solicitor, cited section 47 of the Singapore Act in his written submissions at page 23, where there is an express prohibition to vary the award except as provided under this act. There is no such provision, and section 5 is not akin to such a provision. So I would submit that both by the doctrine of implied powers as well as by the doctrine of molding the relief, there is sufficient power in a 34 court to modify the award, albeit in a disciplined and restricted way. Let us take the question of severability. My learned friends fairly accepted that the general doctrine of severability is now well accepted under 34. And I've given just 2 judgments in this compilation. I won't read them. JG Engineers at item 4. That is at page 52. Your Lordship's Court, where at paras 24 and 25, certain claims were severed from other claims and they were upheld, and the other claims were set aside in the award. And the case of Jivani of the Bombay High Court, which is the last judgment, page 804, where a full bench again upheld this doctrine of severability in section 34. Now, what is important, in fact, my Lord the Chief Justice has been pointing this out, is that the express language of 34, 2A4, the proviso, which contemplates severability, very clearly is restricted only to severability of such matters that fall within the scope of reference and to sever those that fall outside the scope of reference. If that was the limited doctrine of severability, none of these judgments could have been delivered. Because these judgments are on the broader doctrine of severability. My Lord, just see 34, 2A4 for a moment. (34)(2) says an arbitral award may be set aside by the court only if A, the party making the application establishes on the basis of the record of the arbitral tribunal that, small Roman 4, the arbitral award deals with a dispute not contemplated by or not falling within the terms of the submission to arbitration, or it contains decision on matters beyond the scope of the submission to arbitration. So the express recognition of severability is limited to what falls within the scope and what is outside. Yet, your lordships and other courts have repeatedly applied the general doctrine of severability to save awards. And my learned friends accepted that that is part of section 34. So here is one classic example where the express language of 34 does not extend to such a power, but courts have always read that power in. Why have they read that power in? It is because they are cognizant that 34 is a recourse provision, and that the aim and object of the Act is finality and speed of dispute resolution. If an entire award had to be set aside merely because one portion of it was vitiated by, say, patent illegality, and the others were clearly separable, then it would not subserve the aims and objects of the Act, and would not then be a correct exercise of jurisdiction under section 34. That is why the general doctrine has well been accepted. Now, the doctrine of severability generally is nothing but modification of an award. An award starts on a particular footing. When it comes to the 34 court, it starts its life as a decree, as it were, on a totally different footing because one has severed parts of it. That is a clear modification and a power to modify. Indeed, your lordships sitting in a 3-judge bench in Western Gecko, 2014, 9 SCC, page 263. 2014, 9 Supreme Court cases, page 263. Item 5 of this compilation.
Yes.
At page 72, paragraph 40, page 89, have referred to the power of modification, basing it on the doctrine of severability. My Lord, we'll just see para 40 for a moment, page 89. It is neither necessary nor proper for us to attempt an exhaustive enumeration of what would constitute the fundamental policy of Indian law, nor is it possible to place the expression in the straitjacket of a definition. What is important in the context of the case at hand is that if on facts proved before them, the arbitrators fail to draw an inference which ought to have been drawn, or if they have drawn an inference which is on the face of it untenable, resulting in miscarriage of justice, the adjudication, even when made by an arbitral tribunal that enjoys considerable latitude and play at the joints in making awards, will be open to challenge and may be cast away or modified, depending upon whether the offending part is or is not severable from the rest. So 3 judges have accepted that severability is a facet of modification, and that if the conditions for severability exist, there is a power to modify. Now, My learned friend, Mr. Datar, cited several judgments, Your Lordship, and obviously I won't repeat them, on even the power to add words. I believe with the submissions I've made just now, there's no necessity of adding words. It's part of the recourse and the setting aside power that you can sever and or modify. Because the first step in modification is severing. If you can't sever the vitiating part, then you can't modify. Modification only means that if I've already decided that this is the correct position in law, and completely erroneous and patently erroneous position has been followed, then surely one can replace that portion of the award with the correct position in law. Take a classic case of limitation. Let us take an award where a party has completely succeeded on the contract or the transaction. Evidence has been left. The facts are undisputed. Liability claim is quantified, undisputed. But the tribunal says it is time barred under article so-and-so. Now, if the 34 court feels that in fact the wrong article has been applied and the period of limitation is longer, if the correct period of limitation had been applied, the claimant and the petitioner would have succeeded. It would be a travesty of justice for it to relegate that claimant to a fresh arbitration, to run the entire gauntlet of trial and evidence all over again before a fresh tribunal, just with an application of the correct position of law. For I would submit in such cases, it is indeed the duty of the 34 court and well within its powers to make that modification. And I'm not today getting into a distinction between rate of interest. Is it rate of interest only that you can modify, or is it other things? My formulation is, please read in a power of modification, restricted to the guardrails and discipline of 34. That is to say, something that must be on the basis of the factual record and determination of the tribunal as it exists. No reappreciation, no entering into merits. But if you find that patently there is an illegality, which you have corrected in order to set aside the award, then why set aside the entire award? If the entire process of arbitration and award can be saved by merely incorporating your correct determination of law into the award. Your lordships have done that repeatedly, but under Article 142. Now, every matter cannot come up to your lordships under 142. That will be a flood of matters there. Therefore, I would respectfully submit, it does make sense to read this power into 34 as an implied power and within the larger power of annulment or setting aside, because 34, as 34.1 tells us, is a recourse provision. It's not just an annulment provision.
Secondly, the tenor of 34.
Yes.
Though the marginal note says setting aside.
Yes.
Read entirely with special focus on 34.4.
Yes.
Shows that the idea is to uphold the award.
I'm obliged.
Final power is really to uphold the award.
I'm obliged.
Though couched as setting aside.
And that is completely consistent with the object and aims of the Act. And my lord is right to refer to 34.4. If 34 only had a power of annulment, then there's no question of 34.4.
Otherwise, your implied power argument won't sit in, because the final power is to set aside. By modifying, the final power is not effectuated. In sum and substance, the power is really to make an endeavor to uphold it within the parameters of law.
I'm obliged.
In exercise of that final power, if there is a power to effectuate that final power, should the court be deprived of it?
Lordship, I am grateful, my lord. May I adopt that as my submission, my lord? I'm grateful to the court for putting it so it's illegal. Now, the judgment in Seaford, which my learned friend read, I must just, for the record, point out also that in Bangalore water supply, 7 judges of our court have expressly accepted that principle. And that's the judgment at item 6 of the compilation, page 90. And the relevant portion is at para 40. I'm sorry, they're at para 19, at page 109, where the Seaford passage. para 19, I'm so sorry.
One line.
19 at page 109. And we always tend to cite the latter portion of this para, which is a court should iron out the creases but must not alter the material. But the earlier portion also is very interesting, and may I just show that to my lords at the bottom of page 109. My learned friends read a bit of it just now. The quotation is of Lord Denning: the English language is not an instrument of mathematical precision. Our literature would be much poorer if it were. He must set to work, that is the court, in the constructive task of finding the intention of Parliament. And he must do this not only from the language of the statute, but also from a consideration of the social conditions which gave rise to it and of the mischief which it was passed to remedy. And then he must supplement the written word so as to give force and life to the intention of the legislature. A judge should ask himself the question, how if the makers of the act had themselves come across this ruck in the texture of it, they would have straightened it out. He must then do as they would have done. A judge must not alter the material of which the act is woven, but he can and should iron out the creases. Now, please apply this squarely to our position. 34 is a recourse provision. And as my Lord Justice Vishwanathan put it to me, in fact, the substratum of 34 is to try and save an award rather than to nullify it or annul it. That is the material of section 34. All that it requires for your lordships to do is not even add words in, but interpret 34 as including the ironing out of this crease, that if you can, within the discipline of 34, modify the award by incorporating the correct position of law and obviously then consequential changes to the award, just by that, without reappreciation, would that not subserve the mischief which was intended to be remedied by the Arbitration Act, which is protracted litigation, cost, etc., and in fact subserve arbitration and subserve the Arbitration Act? Because the argument on the other side, with utmost respect to all my learned friends, does not subserve arbitration. It defeats it. It defeats the whole aim of arbitration to take such a rigid and inflexible approach. And I don't believe section 34 is not admitting of some play in the joints which your lordships cannot interpret.
Taking a cue from what you read out, Mr. Karnataka.
Yes, ma'am.
This is an issue which has been vexing this court at least since saw pipes in 2003.
I understand.
The Parliament had the occasion to amend this act twice,
Yes.
2016-19.
Yes.
We cannot presume that they were unaware of this problem,
No, of
which
course.
is vexing this
Of
court, vexing the very institution of arbitration. In spite of that, they have not made a change.
That is true.
This is something that Justice Nariman has touched upon in Hakim also.
That's it.
How do you get over that?
Yes. I would put it this way, that if your lordships are satisfied on an interpretation that the power exists in 34, then the fact that Parliament has not thought it fit to make an express provision would not alter that determination or interpretation of 34. It may be that the position would have been much clearer had they put in a separate subsection. But equally, they didn't put in a subsection on the Doctor General.
Does it not convey the intention of the Parliament that there is no requirement for a change? They left it as it was despite being aware of the problems that
My lord is right.
was facing.
That is certainly a factor that your lordships can take into account to interpret 34. But on the other hand, if the plain language of 34 admits of a wider construction and interpretation, the fact that Parliament chose not to put in a specific provision should not alter that interpretation. That's my submission. And I'm sorry. Therefore, my respectful submission is either the fact that this was before Parliament or even the fact that the 1940 Act contains Section 15. I understand the solicitor, my lords have seen Section 15. I won't go through it again. But Section 15 is only the equivalent of existing sections under today's Act. So 15A is the separability provision of beyond the scope of reference, and B is imperfect in form or obvious errors. C is accidental slips or omission. 33 covers that. So 15 is not different in that sense from the position even today. And therefore I come.
If one goes by 15,
Yes,
A is obviously included.
it's included.
It's in perfect form. It is an obvious error that's also included.
Yes.
An award contains a clerical mistake or error resulting from accident, slip or omission. This is obviously an implied power which every court has.
Would always have. Would always have.
Because they suppose while writing the final part of the award, a figure mentioned omits 2 zeros.
Absolutely.
Or
That will
1
always be
zero.
part. That was always.
That will be, you can't say that the
33A covers it.
33A.
And 33A itself gives you the right even to go back to the tribunal if you would so wish. So 15 is really covered. There's no absence of 15. In fact, the acts are in paramateria and therefore the report.
And what was material at that time when we implemented the 1996 Act? Let's not forget. That was the occasion in 1990, liberalization has started.
Yes.
We were expecting foreign investment to take place. And normally arbitration is the method of dispute resolution resorted to in cross-border dispute.
Not. My lord.
That's a default mechanism. Court decisions are not default mechanism.
And finality. What the litigant wants is finality.
Whatever it is, but that's because every party invariably, when they want to invest or have a corroboration agreement, they insist on arbitration. Unlike courts being the default mechanism as far as internal disputes are concerned.
And unfortunately, many of them insist on a foreign-seated arbitration.
That's something separate. That's also changing.
That is changing, and the 2015 amendments, which ring-fence international commercial arbitration, has gone a long way in ensuring that. Now, even foreign parties are more than happy to have India-seated arbitrations. And because of your lordships and other high courts, pro-arbitration.
So that's not
right.
That's not the issue.
That's not the issue. I'm not.
So what happens was we adopted the unilateral model,
Yes.
which is basically framework also of the New York Convention.
Lordship.
More or less on that. We adopted that model and we just simply did it. But if one goes by that, normally we say we have to interpret the intent of the legislation. But while doing so, we have to be practical also, because legislation never meant that they will be impractical or something which is so obvious, which will be looked upon or can be overlooked by us.
My lord, if the intent is speed and finality, then fettering or making 34 rigid is contrary to that intent. So a purposive interpretation of 34 would only result if this limited discipline power modification is read into 34. Otherwise, it would be contrary to the intent.
There's another aspect. Yes, they have been, earlier the amendments were always very infrequent, very, very rarely done. Now, but the good thing which has happened is amendments have been taking place, whether it's the IBC Companies Act or for that matter, Arbitration Act, whenever they have found that there are problems. And if one goes by the latest amendment, which is a proposed amendment, we don't know whether it will be. There is a provision now dealing with modification.
Yes, now there is. But what happens in the interim is really.
We don't know.
We don't know what might happen.
We should not go into that case.
So I'm assuming that there's no express provision. My argument is based on that. But there's certainly an implied power of provision, and that can be read into the existing provision as well. And this would not be contrary to parliamentary intent. In fact, it would subserve the intention of the legislature.
And according to you, there is no prohibition also.
There's no prohibition, unlike Singapore, which has an express prohibition. I am aided in this by the very fair submissions of the learned solicitor. My lords would kindly turn to his written submissions at page 137. Para 174. In fact, para 172 at page 136. (172) at page 136. This is under the part that is headed Possible Ways of Reading in Power Modification. These are the Solicitor General's submissions, the actual written submissions, not the compilation of the actual submission. Para 172. However, after referring to Hakim's judgment in 171, the learned solicitor submits, however, such literal and stringent interpretation of Section 34 of the 96 Act has posed many practical challenges. One recurring issue is regarding the calculation of interest, wherein the award suffers from no infirmity other than that of awarding an exorbitantly high or cut rate of interest. However, in absentia of provision regarding modification, the courts are left with limited remedy, i.e., either to set aside the award or remand the matter as per circumstances in subsection 4 of 34. Then he goes into the conflicting decisions. Page 174. After in 172 and 3, he sees the decisions of your lordships. In 174, he makes a submission. It is submitted that reading modification power into section 34 of the 96 Act is in furtherance of the object of the 96 Act. He's absolutely correct. It is settled principle that a statute must be construed to make it effective and workable. And then para 176 at page 138. Practically, the absence of a modification power leads to wasted judicial resources, as courts often have to set aside entire awards, even when a minor correction would suffice. This contradicts the pro-arbitration approach of minimal judicial interference and speedy dispute resolution. While it is accepted that courts should not rewrite awards or review merits, a narrowly tailored modification power limited to curable defects would align with the objectives of arbitration law while ensuring justice. But if he then says this again ought to be appropriately dealt with by the legislature. But in para 174, he says even under 34, there is a modification power. So on objects, the learned solicitor has very fairly stated, speed, finality is the object.
In the beginning also he said that there are problems.
There are problems. He was very fair in making that statement. Now, that's the first basis on which I would submit your lordships can read in a power. But there is a completely independent basis as well, which I got to quickly go into. This is the basis of inherent powers of a court. A court hearing matters under the Arbitration Act, a special statute, would nevertheless retain the character, its own character as a civil court. The definition of civil court is in 2(1)(e). And that can sometimes be a district court, my Lord Justice Gawai gave the example, or it could be the High Court, depending on where you are. Because sometimes the High Court has original jurisdiction and therefore would be the district court for those areas. I'm going to deal with the two of them separately, if your lordships permit me. As far as High Courts are concerned, when they exercise the 34 power, they remain constitutional courts of record under Article 215 of the Constitution. No part of that power can be ceded or taken away, even by Section 5, which is a statute, even assuming Section 5 can be extended to the powers of the 34 court, that can't be taken away. Your lordships have held so in the context of Articles 226, 227, and other articles, that the High Court's constitutional powers conferred on it by 215, and in fact pre-existing as courts of record, cannot be taken away by Section 5. Just as your lordships, Article 142 powers cannot be taken away by Section 5. Because these are constitutional powers. Now, two judgments very briefly on this aspect of what is a court of record and what is its scope, ambit of its power. The first is in the celebrated Mirajkar case, Naresh Mirajkar. And that, my Lord, will find in the additional compilation at item 9 at page 463. This is 1966 3 SCR, page 744. If my lords are pleased to go to running page 486 of the compilation, para 59. Para 59, running page 486 of the compilation. There is yet another aspect of this matter to which it is necessary to refer. The High Court is a superior court of record, and under Article 215 shall have all powers of such a court of record, including the power to punish contempt of itself. One distinguishing characteristic of such superior courts is that they are
Just one minute.
I'm sorry, running page 486 of the law. There is yet another aspect to which it is necessary to refer. The High Court is a superior court of record, and under Article 215 shall have all powers of such a court of record, including the power to punish for contempt of itself. Then the para goes on to say, such superior courts have the power to determine their own jurisdiction. And then about 2/3 of the way through the para, 10 lines from the bottom of the para, in support of this view, this court cited a passage from Halsbury's Laws of England, where it is observed that, quote, prima facie, no matter is deemed to be beyond the jurisdiction of a superior court unless it is expressly shown to be so, while nothing is within the jurisdiction of an inferior court unless it is expressly shown on the face of the proceedings that the particular matter is within the cognizance of the particular court. And then we go on to para 61 at page, it starts at the bottom of page 486, but the portion at page 487, the last 4 or 5 lines of para 61. Therefore, in our opinion, having regard to the fact that the impugned order has been passed by a superior court of record, in the exercise of its inherent powers, the question about existence of the said jurisdiction as well as validity or propriety of the order cannot be raised.
This will be a slightly truncated argument. That will be giving some specific powers to the constitutional court.
Constitutional court. So that would,
That may not be.
therefore, I'm making that slight distinction.
That power will be available only to the High Court and not to the.
That is true. That is true. Therefore, I say I'll deal with both separate. I'm going to deal with district courts.
This will be little more.
May I just place the point, my lord? There are several other paras which.
So if an arbitration arises in Thana,
It may have problems.
No, there is a remedy.
You'll have to section 38(4) bars.
No. I'll tell my lord why that doesn't help, because the second limb of the argument is that the CPC will apply there, and one will have 151.
No, you have already raised that argument. Don't stretch it.
Very well. Just one more judgment, my lord. M.M. Thomas. That is at page 527 of the compilation.
527.
527. This is a 2-judge bench. 2001 SCC 666. And if my lords kindly go to para 14 at page 533, there is a useful summation of the law there from paras 14 to 17. In para 14, your lordship says the High Court is a court of record as envisaged in Article 215 of the Constitution, must have inherent powers to correct the records. A court of record envelops all such powers whose acts and proceedings are to be enrolled in a perpetual memory and testimony. A court of record is undoubtedly a superior court, which is itself competent to determine the scope of its jurisdiction. Then page over. On the top of the page, they refer to the Mirajka judgment, then the passage from Halsbury, and then in parenthesis after the passage from Halsbury, the Supreme Court notes that though the references to English courts, the principle would squarely apply to superior courts in India also. And then 16. Referring to the said passage and relying on the decision of this court in Naresh Mirajkar, a 2-judge bench of this court in M.B. Elizabeth has observed, quote, the high courts in India are superior courts of record. They have original and appellate jurisdiction. They have inherent and plenary powers, unless expressly or impliedly barred and subject to the appellate or discretionary jurisdiction of the Supreme Court. The high courts have unlimited jurisdiction. So if a high court is hearing a section 34, one cannot say it doesn't have the power to correct the record, because ultimately the award will be treated as a decree of the High Court for execution purposes. One cannot say its inherent or plenary power to correct the record is taken away completely because of section 5 of the Arbitration Act. This is a power that pre-exists pre-Constitution, reaffirmed by Article 215 of the Constitution. And one other judgment of your lordships, in Jyoti Bhushan's case, item 12, page 550, slightly different point.
500 and?
550 of the compilation. This is in 1962 supplement 1 SCR, page 73. The relevant para is paragraph 9, which starts at page 553. May I go straight to page 554 to save your lordship's time and read the last portion of para 9 at page 554. After the extracted portion on the top of 554, there is a paragraph starting with counsel for the appellants. About halfway through that paragraph, after referring to the Privy Council decision, the sentence starting with the jurisdiction to deal with the claims of companies ordered to be wound up is conferred by the Indian Companies Act, and to that extent the letters patent are modified. There is, however, no difference in the character of the original civil jurisdiction which is conferred upon the High Court by letters patent and the jurisdiction conferred by special acts. When in exercise of its authority conferred by a special statute, the High Court in an application presented to it as a court of first instance declared its liability to pay a debt, the jurisdiction exercised is original and civil, and if the exercise of that jurisdiction does not depend upon any preliminary step, invoking exercise of discretion of the High Court, the jurisdiction is ordinary. So even under the Arbitration Act under 34, it is the ordinary original civil jurisdiction which is plenary in its scope.
That's KMG or Grindlace?
Now, my lord, as far as
Just
other courts are concerned, I'll be very brief. I have 2 or 3 judgments and points and I'll be done. In ITI Limited and Siemens, which your lordships will find at page 717 of this very compilation, two judges of this honorable court. The citation is 2002 5 SCC 510. And at para 13, which is at running page 724 of the compilation, the court negatived the argument based on section 5. And I quote, "We also do not find much force in the argument of counsel for the appellant based on section 5 of the Act. It is to be noted that it is under this part, namely part 1 of the Act, that section 37(1) of the Act is found, which provides for an appeal to a civil court. The term court referred to in the provision is defined under section 2E of the Act. From the said definition, it is clear that the appeal is not to any designated person, but to a civil court. In such a situation, the proceedings before such court will have to be controlled by the provisions of the code, and therefore the remedy by way of revision under section 115 of the code will not amount to a judicial intervention not provided for by part 1 of the Act. To put it in other words, when the Act under section 37 provided for an appeal to the civil court and the application of the code not having been expressly barred, the revisional jurisdiction of the High Court gets attracted. If that be so, the bar under section 5 will not be attracted because conferment of appellate power on the civil court in part 1 of the Act attracts the provisions of the code also." Now, as I pointed out, the next judgment at page 728 in MTNL, also of 2 judges, says we are bound by ITI, but we disagree with the statement of law. We find the statement erroneous and they referred it to a larger bench. That is in 2017 2 SCC page 37. But that reference is still pending. To the best of my knowledge, subject
which is the paragraph 11?
Paragraph 11. In MTNL para 27, I'm sorry, para 27. At running page 741, the last page of the judgment. And they do so on the footing that they say the Arbitration Act is a complete code. Now, if ITI is correct, then the CPC applies, which includes 151. So all courts, including district courts, will have that power. The necessity is for your lordships to define what that power is and to ensure that it's strict and disciplined within 34. That itself will be enough. Now, my lord, one last judgment of your lordships, which I must place before my lords, is the bench of 7 judges in the Stamp Act matter. It is item 13, page 556 of this compilation. I want to just read 4 paragraphs, 4 short paragraphs from this judgment. This is reported in 2024, 6 SCC, page 1. First para is para 67 at page 627. At 627, para 67, your lordships hold. Arbitration is a method of alternate dispute resolution where parties agree to refer their disputes to a neutral third party known as an arbitrator. Running page 627 of the compilation. I'm so sorry. Para 67. Arbitration is a method of alternative dispute resolution where parties agree to refer their disputes to a neutral third party known as an arbitrator. The aim of arbitration is to provide speedy, efficient, and binding resolution of disputes that have arisen between the parties in regard to their substantive obligations. The thrust of arbitration law is succinctly encapsulated in Redfern and Hunter. It is to be expeditious where the law is slow, cheap where the law is costly, simple where the law is technical, a peacemaker instead of stirrer of strife. Relegating a successful party to a new round of arbitration, stirrer up of strife. It cannot be in consonance with the objects of this act. Then if my lords see para 81 at page 631. This is a little important because my lords have interpreted section 5 and given its correct scope and meaning. In para 80, section 5 is set out. But then if we go to 81 at page 631 of the compilation, what your lordships have held is this. One of the main objectives of the Arbitration Act is to minimize the supervisory role of courts in the arbitral process. Party autonomy and settlement of disputes by an arbitral tribunal are the hallmarks of arbitration law. Section 5 gives effect to the true intention of the parties to have their disputes resolved through arbitration in a quick, efficient, and effective manner by minimizing judicial interference in the arbitral proceedings. Parliament enacted Section 5 to minimize the supervisory role of courts in the arbitral process to the bare minimum and only to the extent so provided under Part 1. In doing so, the next sentence is very critical. In doing so, the legislature did not altogether exclude the role of courts or judicial authorities in arbitral proceedings, but limited it to circumstances where the support of judicial authorities is required for the successful implementation and enforcement of the arbitral process. Therefore, an interpretation of 34 that supports the arbitral process, supports the aims of finality and speed, is not contradictory to section 5 at all. And then one more para.
But subject to what Mr. Banerjee and Mr. Kripal may say, you may also consider this.
Yes, ma'am.
Instead of this bifurcation between high courts and civil courts.
Yes, ma'am.
See, section 5, if it is to be construed as a bar, this court, even in the context of a constitutional bar in 329,
Yes,
has said that anything in furtherance of the object
precisely.
will not be impeded. If it is to frustrate, yes, we will invoke the bar. So section 5 will not come in the way of any interpretation which furthers the object of the act. In a way, what 81 says, if you have support in the constitutional context,
I'm truly obliged. That is
subject to what they
that
say,
is precisely what the 7th
Not be read
Judgment
as-
said in para 81.
then the last words, unless provided in the act, will be read to mean that 34 implies this power. This is of course subject to what they say.
Lordship. 81 clearly holds this in interpreting section 5. One more paragraph, 84, at the bottom of page 632 of the compilation. After setting out the non-obstante clause in which section 5 starts with, para 84, what your lordships say is although a non-obstante clause must be allowed to operate with full vigor, its effect is limited to the extent intended by the legislature. In ICICI Bank and Sitco Leathers, a 2-judge bench of this court held that a non-obstante clause must be interpreted by confining it to the legislative policy. Thus, even if a non-obstante clause has wide amplitude, the extent of its impact has to be measured in view of the legislative intention and legislative policy. In view of this settled legal position, the issue that arises for our consideration is the scope of the non-obstante contained in Section 5. And then the judgment in Morgan Securities is also cited. And the last line of para 85 says, in other words, the scope of the non-obstante clause is limited to prohibiting the intervention of judicial authorities unless it has been expressly provided for under Part 1 of the Arbitration Act. So, judicial intervention, if in support of the aims and objects and legislative policy, is not proscribed by Section 5 at all, because that would turn it on its head. Section 5 can't be used as an instrument to destroy the objects of the Arbitration Act, which is speed and finality, and which it would be if it is used as a fetter on Section 34, power of modification in certain limited and extenuating circumstances, to prevent a miscarriage of justice, to correct a patent error of law, the correction of which alone turns the award. Take my own case. I know my laws are not going to facts, but as an example, the three applicants, one is an 82-year-old widow who's been out of her home now for almost over 20 years, and her two sons. The award, the tribunal, we succeed completely on an agreement that is entered into, specific performance, our right to get our alternative accommodation, which was promised to us under that contract, readiness and willingness, everything the tribunal upholds. But then it says in one pithy paragraph, and I'm not obviously in challenge before your lordship, that these three are fiduciaries of the company with which they entered into the contract, ignoring the fact that the mother was not even a director of that company, but of some other subsidiary or associate company. One of the sons was not a director. One son was a director, but admittedly did not participate, and under Section 88 of the Trust Act, did not avail himself of his character. But it's like, too bad. Therefore, this contract is bad unless approved by the shareholder. Just in one sentence, contrary to a lot of judgments that we cited. Now, that's patently an error of law on the face of the award. The dissenting judgment, in fact, decides again everything in our favor. On this point, says no question. 88 has no application. And these are not fiduciaries. Ex specie, a non-director can't be a fiduciary unless there's some other capacity pleaded, which in this case there's not. Now, in such a case, if the 34 court feels that that 2 or 3 sentence unreasoned finding on law is patently erroneous, and the correct law is that they are not fiduciaries, and 88 does not apply, then surely it should be permitted to incorporate that into the award, and with consequential changes, that's the end of the matter. If I succeed in 34, the matter is still pending, the best result I can get is restart the whole arbitration. 82-year-old widow has to restart a whole arbitration with evidence, trial, etc. Now, I've just prepared a one-page note, if your lordships, on the facts of my case. I've already summarized them, so I don't want to read it again.
No, facts of the case, to be very frank, will not be.
But as an example, only as an example. Now, my lord, therefore, I come to the final part of my. So just
But
one.
sure, there is an intervener gotten, but we don't even know whether the other side is here or not.
Wait, I'm not asking my lord to go into facts. I'm arguing it only as
But
an
you
example.
can say not facts of your case in a given.
In a given case, I appreciate that. No? In a given case, this could happen. I gave another example of limitation that is equally unfair and harsh. And to decide that an award is vitiated by patent illegality, of necessity, the 34 court would have to say and determine what the correct position of law is. So there's no extra determination being done there. So that approach would end a dispute rather than perpetuate it for generations. I mean, I just refer to it. I won't cite it. In Deep Industries, which is also set out in page 535 of this compilation, 2020-15 SCC 706, para 17, my lords have held, constitutional powers can't be taken away by Section 5 of the Arbitration Act. Therefore, I come now to the summation. I commend to your lordships to follow, in part at least, the procedure and law in England. In England, there is an express variation power. Let us be very clear about it from the beginning. But it's couched in general terms, power to vary the award. That's all it says. But English courts and English commentators have narrowed that power And the best enunciation of that narrowing of the power is found in Mustel and Boyd, which my lords will find at page 260. Just one sentence of this compilation. At 261, varying the award, one sentence. Heading starts varying the award. First sentence is an order varying the award will not necessarily result as a matter of.
From what?
Mustel and Boyd, second edition.
Okay.
261. Order varying the award will not necessarily result as a matter of course from a successful appeal. We suggest that such an order will only be appropriate where the variation, including any variation of the award on costs, follows inevitably from the court's determination of the question of law. So it must then be obvious. It doesn't require a revisitation, reappraisal, a redetermination of anything. And English courts have held, including the judgment in Fencegate at page 265 of the compilation, that even this wide power of variation is restricted to the two essential requirements. And I'll just state them for my lords. One is, it must not involve a fact-finding exercise. You must take the arbitral records as you find it. No variation, reappreciation of facts. And the second is this. The variation must flow inevitably from the court's determination of law. Yeah, I've said that. I'm not reading it, my lords. It's in my written submission that I've referred to it. Therefore, if we apply a similar principle to 34, what is the discipline of 34? The discipline of 34 is it's not an appeal. One cannot reappreciate evidence. One cannot go into merits. That is an express prohibition in 34. However, if any part of the award is vitiated by a patent illegality, that part can be severed if the conditions